Welcome everybody to the 5 St Andrews Hill webinar, part of our autumn series, focusing tonight on the modern slavery defence, now section 45 of the Modern Slavery Act. My name's Chris May. I'm an exclusively criminal practitioner, for those of you who may not know me. 3 of us will be taking different aspects of this seminar this evening, and each of us will be looking at a slightly different angle. The idea is that it's a defence-orientated update on the Section 45 defence, where it is now in various different aspects of it. So there'll be a number of slides being presented, and obviously we'll be asking Tess, who's behind the scenes, to help us with the slides from time to time. That's me, and so if I could ask Sarah and John to introduce themselves, please, for those of you who may not know them.
Hello, my name is Sarah Fairbairn. I am a criminal practitioner at 5 St Andrews Hill.
And I'm John Oliver, also obviously at 5 St Andrews Hill. I principally defend, but I also prosecute in criminal cases, and I dabble in extradition. And that's me.
So as many of you will have known from your own experience, the Section 45 defence is one that's been gaining a lot of currency. It's increasingly something that needs to be considered in a lot of different contexts in criminal cases. And so Sarah is going to be looking at things primarily from the perspective of the Magistrates' Court and looking at things from an early stage of proceedings. So over to you, Sarah.
Yes, thank you, Chris. So I'm going to start just very briefly by setting out what the defence is, and then moving on to things to look out for, both in the police station and first appearances. So up on the screen now, you've got Section 45 of the Modern Slavery Act. You may hear it referred to as the Section 45 defence or the Modern Slavery defence. I'm not going to read it out, and in fact John is going to go over in more detail about the defence and how it differs for over 18s and under 18s, but you can see there Section 1 is the defence in relation to adults. And Tess, if we can move on to the next slide, you've got Section 4 there, which is the defence in relation to under 18s, and you'll get the slides at the end of this webinar, so if you want to look over the full wording of the section, you can do that at the end. But Tess, if we can move on. There are a list of excluded offences in Schedule 4 of the Act. Now this is a long list, and it's not an exhaustive list that is up on the slide here, but any offences which appear in Schedule 4 are offences in which you cannot run the Section 45 modern slavery defence. So as you can see, that includes murder, manslaughter, both Section 18 and Section 20 GBH, robbery, firearms offences, aggravated burglary, almost all sexual offences, and both slavery and human trafficking offences within the Modern Slavery Act itself. As I said, that's just some of the most common offences, but always check Schedule 4 if you have a potential Section 45 case to make sure it's not excluded. So moving on, thank you. So the main thing I want to talk to you about today is warning signs, and in particular for those that practice in the Magistrates' Court and do first appearances, also solicitors who attend the police station. It's very easy to miss a potential Section 45 defence, and the earlier it is picked up, the better. One of those reasons is because this is a defence where if it's not run, in most cases you may be looking at a guilty plea. So if you miss it early on, it may be too late. You may have already advised someone to plead guilty. So it's very important you know what the warning signs are, know what to look out for. one of the reasons why it's potentially tricky to spot the warning signs is because in most cases your client won't know they are a victim of criminal exploitation. They won't tell you they want to run this defence. It's not, for example, like self-defence, where you get a client who sits in the conference room with you and says, I want to run self-defence. So you need to read between the lines in order to pick it up. I'm going to move on shortly to deal with warning signs relating to the offence itself and also relating to the individual defendant. Now, these are a broad brush kind of overview. It's not an exhaustive list, and of course not all factors will be present in all cases, but it's some of the most common factors to look into. And I've given you a couple of acronyms to help you remember these warning signs. So when we're looking at the offence itself, the acronym is LOOT, so location, offences, others involved, and telephones. And if we move on to look at those in more detail, so in terms of location, when you're looking at your case papers, where was the defendant arrested? Now, in most cases, when we're dealing with Section 45, we're dealing with county lines cases. So was your defendant arrested in an area where he has no connections? So, for example, if your defendant is from London, he's arrested in a regional town somewhere where he doesn't really have any reason to be. That is a common red flag and a warning sign. Also, was he arrested on public transport or in a train station? In county lines cases, usually the defendants travel to and from London on trains, and it's quite common for them to be picked up by the police at a train station or on public transport. It's also quite common for a defendant to be arrested in a cuckooed house. So again, in county lines cases, a house is often taken over of someone vulnerable in that regional town, and quite often that's where your defendant will be arrested. So if they're arrested in any of those areas, that's one of your warning signs. Moving on to the first O, offence. What type of offence has the defendant been charged with? Now, I've already touched upon the excluded offences in Schedule 4. But by far the most common offences where you may be running this defence are possession with intent to supply, usually Class A, but it can be Class B, and possession of bladed articles or offensive weapons. And that's because, as I've already said, it's usually in county lines cases. So if your client is charged with one of those offences, again, look a little bit more closely at some of the other factors and see if they apply. The second O, others present. Was anyone else arrested alongside the defendant? If they were, who were they? Are they people older than the defendant? Are they people where your client doesn't really appear to have any obvious connection to them, any obvious reason to be with them? If so, that can be a warning sign that this is a county lines case. And what explanation does your defendant give for being with them? And finally, the T, telephone. Was the defendant in possession of a burner phone? County lines cases, it's very, very common for a defendant to have a burner phone with him or her. So if the defendant was arrested with multiple phones, with burner phones, again, that's a red flag to consider. So if I move on now to warning signs related to the defendant, and again, we've got a second acronym to help you remember, and that is appeal. Age, previous convictions, poverty, education, account, and looked after child. So if we go through those in a little bit more detail, starting with age, how old is your defendant? Now, there is no age limit for running a Section 45 defence, but it's very common in cases where you're dealing either with youths or with young adults, so kind of 18, 19, 20-year-olds. Previous convictions. Does the defendant have similar previous convictions? Now, they won't always have previous convictions, but if they do, and if they are for similar offences, that can be relevant. And particularly if, for example, you've got a defendant who has previous convictions for possession with intent to supply, and that was also committed in a different regional location, then that may point to the fact that they have been travelling around different parts of the country. Now, on the flip side to previous convictions, has your defendant successfully argued Section 45 before? Now, you won't get that from the prosecution papers, but if you are a solicitor or if you're a barrister, contact your solicitor. They may have represented this defendant before, and they may know about their history. They may know if this is a defence they've run before. So look into their background and see if that assists you at all. The second P is poverty. So what's the defendant's background? Sadly, it's very common for a lot of these Section 45 cases to have a defendant who's from a low socioeconomic background, experience of poverty and deprivation. And taken together with the E, education, is the defendant in education? Now, this is particularly relevant when dealing with youths, of course. And it's very common for defendants to have dropped out of school, to have been excluded, to have very poor attendance, or be in a pupil referral unit, which is known as a PRU. And more, we're seeing PRUs being used as somewhere to recruit vulnerable teenagers to go and deal drugs in county lines cases. So if your client is in a PRU or has been recently, or has any problems with their education, again, that's another warning sign to look out for. Moving on to the A, account. What account does your defendant give? So in relation to what we touched upon before with location, phones, etc. Why was he in the area? How did he get there? Why was he with the people he was with? Why did he have all those phones on him? In conference, it's quite important that you challenge your client's account. They may often give you an account that you think is an excuse, is covering up for someone else. Now, obviously, you're dealing with vulnerable young people, so do it in a tactful way, but as much as you can, try and push back a little bit and see if you can unearth something that looks like they're covering up for someone. And if they can't give you a good account for why they were there and what they were doing, that may be a warning sign. And also remember that quite often, in fact, in nearly every case, they won't actually know that they are a victim of modern slavery. So, of course, they're not going to tell you that they are. And finally, the L, looked after child, is the defendant in care? And again, as with poverty and education, the fact that your client is in care is sadly a very common characteristic of defendants that are exploited. They're easier to target. They don't have parents that notice that they've gone missing. They don't have parents that notice who they are with. So taken all together, these are some of the most common factors and the warning signs to look out for at that first appearance. So moving on, please, Tess. So just to put some flesh on the bones with regard to those warning factors, this is a case example from a 16-year-old boy that I represented last year. Now, he was arrested in a town where he had no connection whatsoever in the early hours of the morning. He was arrested for possession with intent to supply Class A drugs, possession of an offensive weapon ×2. When I first spoke to him, there were multiple accounts as to why he was there. At one point, he said he'd been visiting an aunt. That then changed to going to a party. He said he'd got there on a train. He had a train ticket. Someone had bought that ticket for him. He wouldn't tell me who it was that had bought it or why they had bought it for him. He was in care. He was not attending school at all. He had very low attendance rates. And he did have some previous convictions for possession with intent to supply and weapons offences from different regional towns around London. And despite him telling me initially that he was there voluntarily, they were his drugs, his weapons, he'd chosen to be there. The more I spoke to him, the more I looked into his case, the more obvious it was that he ticked almost every box for the warning signs. And he did agree to go through the NRM process, and eventually, did take a very long time, but eventually we got a positive conclusive grounds decision that he was a victim of child exploitation and was in forced criminality. So moving on, please, Tess. So just looking more at the practicalities of an NRM referral, who can make an NRM referral? Well, it can only be done by what's called a first responder organisation. And this is a list of organisations who have been authorised to make NRM referrals, and it is an exhaustive list. Solicitors' firms and barristers are not first responder organisations, so if you're representing someone, you cannot make the referral yourself. But what you can do is contact a first responder organisation and ask them to make the referral. Now, the most common first option would be to contact the police. They may already have done one, but in a lot of cases they won't have done. So contact the police, ask them to make the referral. If you're dealing with a defendant who is a looked after child, then the local authority, social services, can also make that referral for you. If the police don't want to do it, and if social services aren't involved, then the most common organisation used by defence solicitors is the Salvation Army. And if we just move on quickly to the next slide, that is the current list of first responder organisations. So you'll see the police force, local authorities, Salvation Army are all on that list, but there are multiple other organisations that can make that referral for you. So next slide, please, Tess. Now, the final topic I want to cover is timeframes. So when an NRM referral is made, there will be a reasonable grounds decision and then a conclusive grounds decision. And John's going to talk to you in more depth about what those involve. But in terms of the timeframes, you should get your reasonable grounds decision within 5 days, and you should get your conclusive grounds decision within 45 days. But anyone that has ever done one of these will tell you that that never happens. The reality is it's much, much longer. And I think at the moment, in many cases, it can take up to 6 months to get a conclusive grounds decision. Now, if you are in the magistrates court or the youth court, then these timeframes are very problematic. We deal with what the legal advisors and magistrates like to call speedy summary justice. They don't like delays, they don't like adjournments. So if you are running section 45, then at your first appearance, when you complete the PET form, try and get that trial date listed as late as possible, at least 3 months into the future. If you are in a court where they don't want to do that, if they want to push it sooner, then make sure that you raise that that's likely to be adjourned. If possible, some courts will let you do this. Don't set a trial date at all, and indeed list it for a case management hearing a few months in the future, so that there can be a progress update and a trial date can be set if need be. If you list a trial date soon, it has to be adjourned once, twice, maybe 3 times. You may get courts that, notwithstanding the fact that you've got a valid defence to run, that they refuse to grant your application to adjourn because they are so fixated on speedy summary justice. So focus on getting that trial put as far into the future as you can do. Less problematic in the Crown Court because there are longer delays, but still get on with it as quick as possible, particularly in a CTL case. And you will nearly always need a further case management hearing for an update. So that's all I want to say. So I'm going to hand over now to John Oliver. John, you're still on mute.
Try again. Thank you, Sarah. So my section entitled Modern Slavery Pre and Post Charge. What I'll do is probably expand a little bit on some of the things that Sarah's mentioned and probably introduce to some extent some of the things that Chris is about to talk about. But my first slide, please, Tess. Once you've made the referral to the NRM or one of the organisations that Sarah's identified makes the referral, it's for the single competent authority to make a decision on, and as you can see on the slide, whether there are reasonable grounds to believe that the person is a victim of trafficking or slavery. And if they find that there are, they move on to consider whether there are conclusive grounds for that belief, and I'll expand on that in a moment. But the single competent authority is part of the Home Office. So they, of course, are bound by international treaties and everything in order to make sure the decisions made in accordance with those treaties and international obligations. But once the referral has been made, if there are reasonable grounds, the person concerned is entitled to a period of what they call recovery and reflection for a period of up to 45 days. Now, Sarah's already mentioned that the idea is that you get the conclusive grounds within 45 days, which is the reason why they made it that period. In reality, the way that works is that they're housed, if they're not already housed, in a safe place with the Salvation Army, most frequently. And various organisations intervene to try to gather information about that person. But if we can move to the next slide, please. So the single competent authority, again, with various organisations, will, including the police, will gather information about the individual, from the individual themselves, potentially from legal representatives, from the police and the CPS. Now, because from the police's point of view, if they are the ones making the referral, it's likely, or sometimes the case at least, that they've identified the potential for modern slavery at the point of arrest. And there are procedures in place that compel the police to find an officer who's specifically trained in interviewing vulnerable people, so that the police interview doesn't just address the issue or the offence for which they've been arrested, but also should ask questions with a view to obtaining information about whether or not that person has been trafficked. So the police interview itself can contain information, and that's fed back to the single competent authority, and of course the CPS. Presumably that would include such things as previous involvements with the police, but it can also include information from social services. And they take into account the victim's behaviour, or potential victim's behaviour, and surrounding circumstances. And again, in a lot of cases, these people have not come to the attention of the police before, and so the information that they have about the behaviour and surrounding circumstances arises from the allegation that gave rise to the arrest in the first place. But of course, legal representatives can provide information if they have it. As far as the test that's applied by the single competent authority, for the reasonable grounds test, the question is whether there are reasonable grounds to believe that the person was trafficked or is a victim of slavery. Obviously a lower threshold than for the conclusive grounds. Is it more likely than not, on the balance of probabilities, that the person is a victim of human trafficking or slavery? Next slide, please. If, as a result of all the investigations that are carried out in the assessments, the competent authority concludes that the person is not, or there are no reasonable grounds to believe that they are, or on the balance of probabilities they can't be satisfied that the person is a victim of modern slavery, they're still entitled to a period of support of 9 days. And I suppose really the purpose of that is there's a test to establish whether or not they are. But even if they don't meet that threshold, that's not to reject altogether the assertion that they are trafficked or in some way vulnerable. So they are provided with some support. And I think agencies get involved to try to help them beyond this investigation stage. But if a negative finding, if you could just pop back one test, please. Thank you. But if the finding comes back and it's negative, it could be that between the referral and the decision, either information's been missed or new information comes to light. It could come to light after the investigation's concluded. And so the referral organisation itself, if it doesn't agree with the decision, can refer it back. And indeed, if you're representing someone, you can ask for that organisation to refer it back for reconsideration in light of new information or something that wasn't properly considered. And there is the possibility of judicial review. Of course, these are public bodies, and you could challenge it, for example, on the basis of a failure to give reasons, failure to apply the tests that I've just set out, on the basis that decisions are irrational in view of the information they have, or that there's been a breach of human rights, and you can find some guidance in the case that's mentioned there. If a negative finding comes along, you can, well, actually, in some respects, this bites whether there's a negative or a positive finding by the authority. If a person is charged, whatever the outcome, but if there's information that nevertheless suggests that the person is a victim of trafficking, there's a potential, and I say potential because Chris is going to talk about more about this, of mounting an abusive process argument before the court. Confirmed in the case of L in 2013, which of course came into, which is before the Act came into force. But the test certainly was where a court considers issues relevant to the age, trafficking and exploitation of the person, the prosecution will be stayed if the court disagrees with the decision to prosecute. And again, it's about gathering together information that would suggest that there's been some blip, as it were, in the process, in the referral process. But again, Chris will talk about that a little more. Next slide. If you have a positive finding overall, that entitles the person to a further period of support. It's not for a specified period. It depends largely on the needs of the individual. It depends with whom they're housed and their circumstances generally, but social services would no doubt get involved if the person is young or vulnerable, and of course the police remain involved. But more practically in terms of criminal proceedings, a positive finding doesn't bind the Crown Prosecution Service. It's not because you get a positive conclusive grounds finding that the CPS will automatically discontinue the case. And in fact, there are many cases in which they don't. It's something they must take into account, but they will also examine the information that's been provided to the authority, to the single competent authority, and make their own assessment of the strength of that evidence, the cogency of the information they have. And of course, the CPS applies a different evidential test when it comes to prosecuting. Single competent authority makes a decision on the balance of probabilities, but the prosecution looks at whether or not there's a realistic prospect of conviction. So even if on the balance of probabilities there's evidence of exploitation or trafficking, if the prosecution think there's sufficient evidence to undermine that and prove to the criminal standard that the defence doesn't apply, if you're looking at the section 45, for example, then clearly that will dictate their decision. But it also, of course, informs their decision whether to prosecute at all. But once you get your conclusive grounds, it is an opportunity for you to make representations to the CPS. And any representations really ought to make reference to the international obligations of the CPS through the various treaties, which I've listed a few there, but you can also make direct reference to the Act. Next slide, please. There are some cases where the reasonable or conclusive grounds are reached after a person has been convicted, either because it wasn't identified early enough in the proceedings or because it wasn't identified until the case is completed. If a defendant's already pleaded guilty, you could apply to vacate the plea. Of course, that might depend on whether or not the person's been sentenced. But if they have been sentenced and the first instance proceedings, wherever they are, have been brought to a close, then there is the option of appealing against conviction. I've put the Court of Appeal Criminal Division, assuming it's a case in the Crown Court, but equally if it's in the Magistrates Court, you could appeal to the Crown Court and have a rehearing and redetermination of the Section 45 issue. There we are. Next slide, please. In terms of running the defence under Section 45, it is for the defence to discharge the evidential burden. So there has to be evidence that relates to each element of the Section 45. And just to recap, the age is probably a given in most cases, but I'll return to that. But the person doing an act in the case of an adult because they're compelled to do it, that it's attributable to slavery or exploitation, and the reasonable person test, a reasonable person in the same situation would have no realistic alternative. There has to be evidence that establishes or addresses each of those requirements. And then it's the prosecution that have the legal burden to disprove one or more of the elements beyond reasonable doubt. How do you satisfy the evidential burden? In the same way that you would in any other case where you have the burden to establish a defence on the evidence by the defendant's own evidence from other individuals, whether family members or associates, information about where they live, where they've worked, if they work, associations, just really broadly, people that they associate with, and also support workers, so social services, youth offending service, you may be able to gather information from them. And I know Chris again will touch on some of this. You may also want to commission expert reports, police reports, by which I mean anything from previous encounters with the police, or even from the Chris report itself. The reasonable and conclusive grounds decision, in most cases, it may not be admissible. It may be that you can get the prosecutor to agree to include in agreed facts the fact of reasonable or conclusive grounds, but more likely you'd want to rely on the information that underlies those decisions. I was about to say something else about that. No, let's move on. It might come back to me. Of course, a lot of these cases involve children. And in fact, the international treaties, particularly the directive of the European Council on the Prevention of Trafficking and Protecting the Victims, which is from 2002, but I can make available if you need it, recognises that children are more vulnerable to exploitation than most adults. That's not to say that there aren't vulnerable adults, of course. But just to compare and contrast for what you have on the screen, in both cases, you have an age requirement. In both cases, the person has to have done an act which constitutes an offence. And in both cases, there's a reasonable person defence. And I just rattled over it previously, but just to go through it a bit more slowly, that reasonable person consideration is a reasonable person in the same situation as the person, and having the person's relevant characteristics would have no realistic alternative to doing the act. And those characteristics are the person's age, the person's sex, their physical or mental illness or disability, if there are any. So those things are common to both adults and children, but the distinction comes under whether or not there's any compulsion. So for the case of an adult did the act because he was compelled or she was compelled to do it, and that compulsion is attributable to slavery or relevant exploitation. And again, you'd need to have evidence to address that requirement. But in the case of a child, you don't have to evidence compulsion. All you need to show is that the act was a direct consequence. There still has to be a nexus, but a direct consequence of the person having been a victim of slavery or exploitation. Next slide, please. That essentially says what I've already said, showing the connection between the trafficking or slavery and the act. The case of Joseph touches on that. It's also worth noting, I realise it's jumping around a little bit, but the Crown Prosecution Service, when making a decision whether to charge or not, in the case of a child, will, despite it not being a requirement on the evidence for the defence to establish it, the CPS might still take into account whether or not there is evidence of compulsion. If there is, it's likely to, or in some cases, it's likely to make it more likely that they won't prosecute. And the last thing, as far as the age is concerned, clearly the way in which the case is run, because of the different requirements under the Act, age can be a relevant consideration. If a defendant puts the age in issue, it's for the prosecution to prove beyond reasonable doubt that the defendant is aged 18 or over. And again, as with any other case in which age is an issue, particularly this arises often in the youth court, information to establish a person's age comes from the police, the CPS, youth offending team, and often an expert age assessment. I dealt with a case fairly recently in which two Vietnamese gentlemen were arrested in a house that had been bricked up, and inside which there was a large cannabis factory, and they were accused of being involved in the cultivation of cannabis. One of the defendants said that he was 17. He looked, I have to say, like he was quite a lot older than that. Nevertheless, it was for the prosecution to commission the report and to look into that issue. Otherwise, obviously, if they can't prove beyond reasonable doubt, then the case proceeds on the basis that he's a juvenile. That's all I propose to say. Can I pass on to Chris? I'll answer any questions later.
Thanks very much indeed, John. I should perhaps have said at the start that if you do have any questions, please feel free to put them in the chat on the screen. And the other thing that perhaps I should have mentioned is that this webinar is assessed as worth 1.5 hours CPD points. So I'm going to look at the position, really focusing on the Crown Court and on the availability of running an abusive process argument, then some practical suggestions as to perhaps some things to do in running a Section 45 defence, and finally a few comments on the Modern Slavery Review 2019. So to understand the context of the current approach, particularly to abusive process applications, it's helpful, I think, to look briefly at the history of where what is now the Section 45 defence has come from, what it's designed to do, and some of the things that it doesn't do. But the origins of what's now Section 45 go back to what's known as the Palermo Protocol of the UN Convention in 2000, which was the Anti-Trafficking Convention. And the purpose of Annex 2 was expressed to be to prevent, suppress and punish trafficking in persons, especially women and children. It's interesting, of course, that that concept is now very, very much wider. In Article 3, trafficking was very widely defined, as indeed was exploitation. Trafficking was expressed to include recruitment, transportation, transfer, harbouring or receipt of persons for the purpose of exploitation. And you'll notice that that wording has found its way very much into the language of the Modern Slavery Act now. Similarly, the consent of the person trafficked or exploited was irrelevant, and a child was defined as meaning a person under 18. And that's what the Modern Slavery Act also says now, that a child is a person under the age of 18, consent is irrelevant. So if we can move on to the next slide, please. The next major stepping block was the Warsaw Convention of the Council of Europe in 2005. Article 26 contained a non-punishment provision. So it's looking at what countries, what states had to do or not do, and the critical paragraph was, each party shall, in accordance with the basic principles of its legal system, provide for the possibility of not imposing penalties on victims for their involvement in unlawful activities to the extent that they have been compelled to do so. Of course, as John's already pointed out, compulsion isn't necessary when one's looking at running a Section 45 defence for a child, say for somebody under 18. It's the critical difference in the Section 45 defence now between those under 18 and those over 18. Compulsion is required for somebody over 18, together with the person having no realistic alternative to doing the act. So far as a person under 18, a child is concerned, they do the act as a direct consequence of either being or having been, so in the past, a victim of slavery or relevant exploitation. And again, the other key difference there between the two over 18 and under 18, if it's over 18, the person must have had no realistic alternative to doing that act, whereas for under 18, a reasonable person in the same situation would do the act. There's again a considerable widening of the defence so far as a child is concerned, which probably goes back to the original concept, the original focus being more to do with protection of children. So if we could go on to the next slide, please. The UK brought this into effect in 2009 when the NRM was set up with a number of competent authorities. Originally, the National Crime Agency, the Home Office. It's now all since April of last year under the auspices of the Home Office. There is sometimes a criticism of a reduced quality of decision making since that change, because prior to the bringing of everything under the auspices of the Home Office in 2019, the NCA decisions were often thought of as being much more comprehensive and much more thorough. But before the enactment of the Modern Slavery Act, there was no UK statute that gave effect to the UK's obligations under the convention and the EU directive that followed. And so the UK's obligations were thought to be reflected by three particular protections. The first being CPS guidance, which indicated the circumstances in which a prosecutor could decline to proceed against an individual suspected of being a victim of trafficking. Secondly, where it was available, the common law defence of duress. And of course, duress has been restricted more and more by a whole stream of Court of Appeal decisions. And it's not very easy, as we all know these days, to run a duress defence successfully. And then the third aspect was the court's inherent abuse of process jurisdiction. And in a number of cases, the abuse of process jurisdiction was invoked, or following conviction, the Court of Appeal would entertain an appeal against conviction in circumstances where it considered that proceedings should have been stayed in the Crown Court had an abuse of process argument been run, or if an abuse of process argument was run and didn't succeed. So if we can go on to the next slide, please. I've set out the CPS policy as it was in 2015. It was subsequently updated, but the three aspects: was there credible evidence of trafficking? Was there a nexus, a sufficient connection between the crime committed and the trafficking? And was it in the public interest to prosecute? So if we could move on, please. There are a number of Court of Appeal cases now, mostly looking at the position prior to the Modern Slavery Act. They've recently been summarized by a case called JXP in the Court of Appeal, which is probably the only case that you need to go to now, as it refers to all the other relevant cases. But the synthesis of what the court is saying on that analysis is that the power to stay was to ensure that the UK complied with its international obligations. And if the court found that the trial court would or should have imposed a stay, then the Court of Appeal would quash the conviction. There's no blanket across the board immunity if you get a positive NRM concluded grounds decision. all sorts of factors had to be looked at, including the seriousness of the offence. And as John's already mentioned, the decision of a competent authority is not binding on the court, although it was felt to be likely that the court would follow it. And in one of the cases, there's quite a strongly expressed sentiment that the court thought that the CPS would be likely to follow it as well. If we could move on, please. So looking at the position now for a case brought now which postdates the 2015 Act. Obviously, you need to run the defence at first instance, but even if you don't, it's possible still in certain restricted circumstances to appeal. The pre-2015 principles still apply. So there will be cases still, not very many probably, but there will be cases where somebody comes along and says, look, I was convicted on pre-2015 principles, but in fact, I had a runnable defense and it wasn't run, and the court will look at those. And so obviously the pre-2015 Act principles will apply to those. For a post-2015 Act case, it can still, strangely enough, be possible to appeal. There's a very recent decision this summer, case called S in the Court of Appeal, where there was an original NRM decision which was negative, and the defendant then pleaded guilty. Subsequently, on the basis of fresh evidence, there was a concluded grounds decision which was positive, and the Court of Appeal allowed that to go in on the appeal, and in that case allowed the appeal. So the key thing to remember from that is that even if you do have a negative NRM concluded grounds decision, that isn't necessarily the end of it. A Section 45 defence can still be, it's hard to do, but it can at least, in theory, be advanced even without one. So let's move on, please, because at the beginning of this year, in February, the court, in a very important case of DS, looked at the position as to the scope of the jurisdiction stay on the grounds of abusive process when the CPS continued with a case following a positive NRM concluded grounds decision. So in that case, what happened was that there was a positive NRM concluded grounds decision. The CPS decided that it was going to continue, and the judge allowed an application for a stay on the grounds of abusive process. The Crown appealed that terminating ruling, and the court considered the position. It looked at the CPS guidance, now, or at least at that stage, it had been updated from the original 2015 guidance to a 4-stage test in guidance set out in 2018, which I've set out there. And if we could move on, please. What the court said was that prosecutors are required to take into account the NRM decision, but must examine the cogency of the evidence, and that the NRM decision should be scrutinized to see the extent that available evidence has been analyzed, weighed and tested, and to assess the quality of any expert evidence. The degree of compulsion must be considered in the light of the seriousness of the offence. Now, that had come from the CPS guidance, but the court in the decision in S expressly said that that was the right approach. So it's not open to the Crown simply to ignore an NRM decision. it must look at all the relevant material. But the key aspect of the decision in DS was the court's decision that the jurisdiction to stay on grounds of abuse should not be widened from normal principles. So it had been widened to deal with situations that predated the Modern Slavery Act. And the reason was that that was part of the way the UK was complying with its international obligations. But now that Section 45 is there, the court's view is that the protections that the UK has to offer are sufficiently legally put in place by the availability of the Section 45 defence. The CPS guidance means it is entitled not to prosecute. There's no positive obligation not to prosecute, but critically, it's for the jury to decide the facts of if a Section 45 defence is raised. So if we could look at the next slide, please. That's a summary of the decision in DS. As I say, centrally, since Section 45, the court decided there is no need for the widened scope of the abuse of process principles. And so normal principles would therefore apply. There's no special category of application for a stay on the grounds of abuse where you're relying on exploitation. One observation the court did make in that case was that if there was sufficient evidence raised of a modern slavery defence, it could result in a submission of no case to answer being made at half time. I think it will be relatively rare that such a submission would be likely to be capable of being raised, but in order to do so, of course, you'd need to get the evidence in as part of the prosecution case or during the currency of the prosecution case, because the submission would have to be that the Crown could not disprove an element of the defence. It's for the Crown to disprove the defence, but it only has to disprove one element in order to succeed. So there would have to be at least one element that was not capable of being disproved, which in practical terms is going to be hard to do. But the court did say it was not for a judge to embark on a review of whether or not they agreed or disagreed with an NRM decision. So if the Crown continue with the case, unless you can get it within the normal principles of abuse of process, in other words, that it's unfair to try the defendant, or because of the behaviour of the prosecution or bad faith, there shouldn't be a trial, that line of defence has really been cut off for cases where Section 45 is available. So you have to run it on the basis of the Section 45 defence if the Crown go ahead. So if we can move on to the next slide, please. One of the things that the Court of Appeal in the case of DS did not decide was the question of whether an NRM concluded grounds decision is admissible in a jury trial. There are two potential schools of thought as to this, but the first question really is whether it is an expert opinion. If not, then it's probably not admissible anyway. There is authority predating the Modern Slavery Act as to whether or not an expert's opinion in general terms as to whether somebody was exploited or not was helpful. The court said in the case of EK in 2018 that such experts' opinions were not helpful. But that's not an authority directly on the admissibility of an NRM decision. and the court in DS specifically said it was not deciding the point. So if anybody says or tries to argue in the Crown Court that the court in DS said that an NRM decision is not admissible, that's wrong. The court specifically declined to rule on that because it wasn't part of the judge's original ruling. It's likely, however, that in many cases a judge will say that it is not admissible. That may be a point to take on appeal in due course if you're unlucky enough to be convicted in due course, because it is a key argument that needs to be decided. So what to do when you're running the defense? Well, whether or not you get an NRM decision in, obviously the defense should call all the evidence that is potentially available. John already touched on this. It may be from social workers, yacht workers, probation officers, family members, bearing in mind that what they can give is evidence of fact, not of opinion. What they can't say is, in my view, he's been exploited. What they can do is say, since XYZ happened, his behavior has changed. He used to be somebody who behaved like this, he now behaves in a different way. So in order to have that evidence available at trial, what's necessary is to get everything, especially from social services. Looking at younger people particularly, there's likely to be a mountain of social services evidence. So push the CPS for disclosure. The CPS should, of course, have considered all that material in making their decision whether or not to charge, whether to continue with the case, particularly if there's a positive NRM decision. In practical terms, a lot of that will not have happened. And so push for disclosure, make Section 8 applications. It's third-party material that the Crown have an obligation to get and to consider. So if we could move on to the next slide, please. Some suggestions for running the defence in the Crown Court. Take control of the defence. Take control of the defence at an early stage. So often defending, we are more likely to be reactive to the Crown. But this is an active defence that needs to be run. And a suggestion that I would make is to produce a chronology or a timeline of events in the defendant's history. Bring in all that you want to in as much detail as you need to from, for example, social services records, and get the prosecution to admit it. The key is to get that document agreed and to get it before the jury, and to get it before the jury at the earliest possible moment. And you can do so using agreed facts. So take control of that document, of that schedule, because after all, it's going to set out your defense in front of the jury. The jury will have it with them. So when a defendant themselves gives evidence, it may be apparent from their manner, from their demeanor, that they might be the sort of person who is vulnerable and susceptible to exploitation. But as to the facts of what's happened, obviously they're likely to be pretty vague in many areas. If you've got that history of the particular defendant in front of the jury anyway in the schedule, you can use that, not just the evidence of the defendant themselves. Even if a positive NRM decision is admitted, the decision on Section 45 is for the jury. The NRM decision does not bind a jury. And as I say, the defense can be run even if there is no positive NRM decision. You can put before the jury all and any material that you have and that you need to. And critically, in the same way that a positive NRM decision would not probably be admissible, a negative NRM decision is not admissible for the Crown to adduce. So object to that if anybody tries to introduce that. And unfortunately, of course, we need to bear in mind always the very long list of excluded offences in Schedule 4. There are an awful lot of offences to which the Section 45 defence just can't apply. Then the last thing that I want to look at is on the last slide, the Modern Slavery Review of 2019. looked at all sorts of aspects of modern slavery. As to the Section 45 defence, key recommendations which were accepted by the government included that the burden of disproving the defence remains on the prosecution. So it's not, as some people were arguing for, something that the defence have to prove to any standard. Once it is raised, evidentially the prosecution must disprove at least one element of it. The review also concluded that the Act strikes the right balance between the potential for misuse or abuse by an unscrupulous defendant and the need to protect victims. And it also, and this I think is an important recommendation, one of the recommendations was that where there is a Section 45 defence, prosecutors should investigate thoroughly whether an individual is a victim of modern slavery. There's a suggestion that the CPS are now, since the decision in S, becoming quite gung-ho about proceeding in cases where there is an NRM included grounds decision, and that they may be doing so irrespective of their obligations, and that even that there's guidance that they don't need to follow NRM decisions. I've seen various aspects of guidance very recently, and that's not in any of the documents that I've been given access to. And the last major recommendation was that there should be no change to the long list of offences in Schedule 4 to which the Section 45 defence does not apply. So that's all I want to say, really, and we can move on, I think, to, we've got time for a few questions. There have been a few, I think, that have come in. If we could turn to those, please.
Yes, I'm just going to deal with, there's two questions being asked about whether the slides and the recording will be emailed. They will be circulated by Tess at the beginning of next week, so that deals with those two quickly. There is a question from Stacey Holland. If you had a positive NRM that is inadmissible as evidence, if the Crown refused to agree a Section 10 admission as to the decision, how can you get that into evidence? Now, that was actually asked before Chris spoke, and I think, Chris, you've largely dealt with that, but I don't know if you just want to very briefly answer that one.
Well, my suggestion would be, because it probably is not admissible, is you call the background evidence. What the Crown should agree or be prepared to agree is the factual evidence that is contained within, for example, social services records, yacht records, and so forth. But there's nothing to stop you calling the evidence. Call probation officers, call yacht workers if they're amenable to your defence. You can call all that evidence as factual evidence to the extent that they're able to speak to it. Of course, what they can't do is say, in my view, the defendant was being exploited. But you can get very close to it because you can set all the groundwork there from their experience of what happened to the particular defendant. Factually, what you'll be doing is, in effect, calling evidence from others who are likely to be professionals, perhaps family members as well, as to the things that they know that happened to the particular defendant. And all of that, of course, will back up the defendant's own account. And as I say, I think a really good way of dealing with it is to get an agreed timeline based on the third-party material. So don't just rely on trying to get the NRM decision in, because I think pretty often you won't manage to. But what you can get in is the material that is behind the NRM decision, because that's what's submissible in evidence. I hope that helps.
Thank you, Chris. Now there's another question from Michelle Clark, who says, has any of the panelists used Dr. Grace Robinson as an expert? No, I haven't. I don't know about you, John and Chris.
I haven't. I don't know if you have, John.
No, I haven't either, but I think she's associated with Nottingham University, and they have a unit that specialises in modern slavery. I think they have a particular interest in county lines type cases, and I think I'm aware of her. I think she has a particular interest in children and child exploitation. So if anybody's looking for an expert, have a look at, I think it's Nottingham University, have a look on there. And they've got a panel of experts, and you might be able to pick and choose the one that you think fits your circumstances, but she's certainly one that looks like she'd be helpful.
Thank you. And there's another question. This question was submitted in advance, and I think John's going to answer this. But the question says, what will trigger an NRM referral in the event of a 17-year-old defendant who was charged with Peewit's Class A and is reluctant to make any comment on modern-day slavery or acting under coercion? Is it true to say that an officer who has been requested for a referral needs to interview the defendant to enable him to start the NRM referral? Does the defendant have to help the officer during the interview that he has been exploited, and should he give details of such a thing?
I actually don't think the person who asked the questions on the seminar, but it doesn't matter really, because it's fairly interesting. It's a shame, because I wanted to ask a couple of follow-up questions arising from it, but I'll just work on a couple of assumptions. But the short answer is, well, firstly, what will trigger the referral? If the police have any information, intelligence, anything about the offence which makes them suspect that somebody under 18 is the victim of modern slavery, they have a duty to report, and they can do that without any consent. If the person is reluctant to make any comment on whether or not they're a victim of modern slavery, I think there are two elements to that. One leads into the second part of the questions, where it says, does the officer need to interview the defendant to enable him to establish or to start the NRM process, and does the person have to help the officer? I suppose answering all of those together, no, the person doesn't have to cooperate. In fact, somebody else has mentioned in a chat that not everyone can see, but only we can, that there are conclusive grounds that are reached at, even when the authority hasn't even spoken to the defendant himself or to family or to anybody that they know. They can make this decision based on information they gather from other sources, the police, the circumstances of the offence, as I've mentioned, social services, youth offending teams, etc. So for under 18s, they're not required to engage, nor is the officer obliged to conduct an interview, because again, there could be circumstances where it comes to light after the interview or after charge or even after conviction, and in those circumstances there's no obligation. It's not a prerequisite to interview the person before going through the process. In the case of an adult, similarly, although of course the adult has to give consent before the referral can be made. Important to remember, though, that even if an adult refuses to give consent to the referral, the authority still has a duty to notify. So they basically send a notification to the Home Office saying, we have reason to suspect that this person might be the victim of trafficking. He or she is not prepared to engage, but we're making you aware of it, so that if at a later stage anything comes up, or if anybody is prosecuted for misconduct in public office, possibly they have something to fall back on. But I hope that answers those questions.
Thanks very much, John. Thank you to everybody who's asked questions or sent in comments. I think one thing that will become increasingly apparent to everybody working in this field is that there is an increasing variety of level of quality of some of the decision making within the NRM, and of course, unfortunately, if a decision is made that really isn't, it is apparently not of great quality, it will be of very little persuasive effect on the CPS. And so one hopes that these decisions will be made properly as a result of really thorough investigation, which is what should happen. So thank you very much, everybody. I hope that's been a helpful exercise. And please do feel free to send in any further comments that you may have. As Sarah's already said, we'll be sending out the slides, and indeed there's a recording. So thank you very much.